Welcome back to the Legal Alternative Podcast with me, Sam Post, joined by Nils as ever. We're back, Nils. Long break.
Yeah.
Both had a summer, both been away. You've dotted around. I've had one big break in Thailand, which we'll probably talk about in a bit and out of the office. But no, good to be back and lots to talk about.
So absolutely, I think
you've got 2 updates. I've got an interesting tribunal case. So no question this week, but we've got lots to talk about. So jump straight in with your first update.
Yeah, so this might seem like a very minor thing, really, but it's I want to talk about it for 2 reasons. One, it's going to probably drastically increase my life expectancy.
Oh, good.
Which might sound extreme. And the other thing is it will drastically increase the life expectancy of people who are applying for visas, because one of the big worries for anybody is the length of time that a visa is going to take. Particularly, a lot of the visas we do quite time-sensitive visas, bringing players over, that type of thing. And to be fair, I think this is a really positive step forward, as trivial as it might sound. So the Home Office has actually introduced an online check your visa processing time service, which, as I say, will cut down a lot of that worry. So it's going to enable applicants to check the estimated processing time for their submitted immigration application. And that's actually for inside the UK applications and outside. And what you've got to do is insert the date that you verified your ID on the ID checker app, or when you went to the visa application centre, if you went in person. And it covers the full ambit. So work, study visas, visitor visas, tourist, marriage, medical visitors, and as well as transit arrangements for those passing through the UK to wherever in the world that they're then going. So it may seem a very minor thing, but even from a selfish point of view, we can now just direct our clients to this and say, or even check it ourselves, that this is how long it's going to take. To be fair to the Home Office, I think that's a really nifty tool.
Really helpful. I could see from my perspective in employment, obviously getting someone in, you've then got a good time estimate to deal with other matters, your contracts, your policies. So seems beneficial all around. Really.
Absolutely. So big thumbs up to the Home Office.
Good. Well, that's rare in this podcast, so it's good to hear something a bit more positive.
I wonder if it'll make my hair grow back.
In terms of me, my update again, starting on what may seem trivial, I think both common things, but again, a important lesson from a case. So do a bit of case law on the podcast. So I'll have to read a bit more than normal. It's a case involving Howison and the Great Junction dental practice. It's got a bit of press, this case, and the headline is that an employee has been constructively dismissed as a result of employees eye rolling. So I think we've all worked in office and we've all seen a bit of eye rolling in our time. And what this case found is that when a claimant or an employee suffers a sustained period of what the tribunal calls hostile treatment, even if some of the issues in the amount of that treatment are trivial on its own, that together they can amount to a repudiatory breach of contract. So just to give you some examples from the case, so Miss Howison endured a sustained period of hostile treatment, including being ignored, subject to being eye rolling, excluded from conversations, having requests refused. So this classic environment, and we get lots of cases like this where people say, oh, they don't like me, or I get excluded from social events, or they're a bit rude or ignore me. And sometimes that again of its own is hard. So, when we get employees say I'm being bullied, that kind of idea of bullying is difficult in an employment contracts. And we've talked about in previous podcasts, where that when we're talking about bullying in terms of harassment, that needs to be obviously connected to a protected characteristic. What we're dealing with here is constructive dismissal, where an employee suffers treatment and as a result of that treatment resigns in response to that repudiatory breach of contract. And I think this case, again, is a useful example of how, of its own, if someone was just to roll their eyes at you in an employment setting, obviously that wouldn't be a breach of contract. But that, combined with some other, of its own trivial treatment, can amount to that to that behaviour. What the tribunal concluded is that the cumulative effect of those behaviours, which were described as rude, isolating, bullying and belittling, in connection with some management inaction, did amount to that repudiatory breach. So that last point, the management inaction, I think is important. So if you are in a management position and you're being told by employees that other members of the team are excluding them, as much as we want to say, well, everyone doesn't have to be friends at work, you don't have to socially get on. If this is someone is being isolated or picked on, you can suffer serious consequences as a result. Compensation in this case, 25,200. Again, not a huge amount in employment settings, but with cost, that's going to be a hefty sum for that company to deal with. So again, useful guide. We know, especially in those management positions, we do need to keep on top of it, even if it's people socially, personally not getting on. So double update. Nils, on to your second one.
Just to comment on that, just before we move on, it shows to me how slow the law is to actually catch up, because I remember taking over a matter from a Fiona who left here, and this was probably 2011, 2012. Where it was that exact scenario where it was somebody who had this sort of general feeling. And at the time we took counsel's opinion, and counsel's view was, you've no chance. And it's taken 14 years. I don't know why I was looking at the date. It's taken 14 years for a kid. That's the first I've heard of that type of behaviour being successful.
I think that's true. I think obviously, as always, there'll be some fact sensitivity in it, and we've, in the time of a case update, we've not been able to delve into that management in action. But no, I agree with you. I think we probably have both in our careers given an opinion on that type of case. That's, you're not meeting harassment thresholds. It's not because of protected characteristic. This is clash of personalities type arguments. So no, it is, and that's obviously why it's got some press attention, that some people think that surely that can't be your eyes at some. But no, I think that's right, and important to point out.
So sorry, I just wanted to going from immigration to employment to data protection. Quite an interesting case that I found this morning called Farley and Paymaster. And we've talked about on the pod in the past how difficult it is to recover damages in data protection claims. And what the Court of Appeal has actually clarified is the rules on compensation, what's called non-material damage. And what had happened before this matter got to the Court of Appeal, is the claims had actually been struck out, or most of the claims had been struck out. So it was a collective action regarding a data breach, and it was 432 people, so a big number of people. They were members of a pension scheme, which was administered by Paymaster. Their annual benefit statements were sent out to outdated addresses. The High Court actually struck out most of the claims for the breach of data and misuse of private information on the basis that the claimants couldn't show that the data had actually been disclosed. That was the position as I actually understood it. That unless you could show that the data had been disclosed and there was a loss that could flow from that, that the claim would be struck out. However, the Court of Appeal has held that the judge was wrong to strike the data protection claim out for requiring proof of disclosure. And what they said was each appellant has pleaded a reasonable basis for alleging the respondent's mistake involved infringement of the GDPR, that being the applicable law at the time of the breach. Rejected the respondent's arguments that the claims should be dismissed for failing to reach a threshold of seriousness, which is what we've talked about in the past. That unless you can, show some level of seriousness, so your pension statement's gone out, you come to us, and I would have said, well, where are we going with this? So they clarified that their view is, the Court of Appeals, that no such threshold exists in EU data protection law. So the Court of Appeals held that compensation is recoverable for non-material damage, including for fear of the consequences of an infringement, if the fear is objectively well-founded, not if the fear is purely hypothetical or speculative. So I think this is really helpful clarification, because it's the Court of Appeal giving with one hand and taking away with another, really. So I think that's really useful guidance, because non-material damage, still able to recover for that, but we're going to have to show that the fear is not purely hypothetical or speculative. So I obviously don't want to comment on this particular case because it's going back down to the High Court, but if your pay slip's been sent out, where are you going to go to say that the fear is beyond that hypothetical? And I think that's still going to be quite difficult. So really helpful guidance there.
Great, and we'll see what the High Court comes back with. Obviously on the facts, we won't speculate too much, but
No.
I think it might be difficult.
Yeah, agreed.
Out the office, we probably should tell listeners what we've been up to, and I've got some things to plug as well. So yeah, both been away. I've been longest I've had off. So part of the podcast break, I was in Thailand for 16 days. So amazing, first time kind of with the kids long haul. So fabulous time, really good, really enjoyed it. And you've been out and about?
Yeah, been to Cyprus. Went for a colleague's wedding out there, which was fantastic. Really hot, really enjoyed it. Great time with the kids. And then went to Dublin, coincidentally, as we discussed in off air, the same weekend that Oasis were playing. So I've never seen so many bucket hats. In one place.
And lots of Adidas apparel.
Yeah. But fantastic weekend to be that sure.
I'd say, obviously, colleagues, congratulations. We've had a few big news in teams, babies and marriages. So busy time at Chadwick Lawrence. In terms of busy time, a bit of a plug for our events and seminars. We've got all of our events just published. So we're doing mock tribunal again. We're doing sickness absence case. Lots of employment updates. I won't go through the individual dates, but if you go on the website, chadwicklawrence.co.uk, and then there's the events and seminars page. All the events, all the sign-ups, all on Eventbrite. So sign up and hopefully we'll see some of the listeners there.
Good stuff. So
it's been good to be back.
Absolutely.
We will now back in the run. We're both in. So yeah, we'll be back next week with some legal updates. And it's goodbye from me.
And from me.